for this hearing. The hearing, as you know, is concerned with the report on examining the legitimacy and legality of the ad hominem term limit waiver for the incumbent president of the Russian Federation pursuant to Resolution 2519 of 2023. And I should perhaps begin by reminding colleagues that this hearing is open to the public and is being live streamed. Now, we are fortunate to have with us three eminent speakers. First of all, Mr. Michael Kasyanov, former Prime Minister of the Russian Federation, Dr. Gleb Bogush of the University of Cologne, who's an expert in public international law, and Ms. Veronika Vilkova, the Vice President of the European Commission for Democracy Through Law, the Venice Commission, some of you may remember her from having spoken this morning on a slightly different topic. So we're very pleased that she was able to join us again this afternoon. And at this point, I would like to turn to the rapporteur, Mr. Peter Omskit, to take matters forward with the experts we now have with us. Thank you so much.
Thank you very much, and thank you for joining us here. We approved the report, which we, by the way, started before the full-scale Russian invasion in Ukraine, on the examination of the legitimacy and legality of the ad hominem term limit waiver for the incumbent president of the Russian Federation. If you remember the report and the Russian Federation, you know that when Putin came to power, there was a term limit of 2 terms of 4 years to be president. And it's very healthy to have term limits, because you get a lot of power. And Putin changed the constitution, changed it twice, and now Mr. Putin, and by the way, also Mr. Medvedev, can be president for 2 more terms of 6 years, so 12 more years. So he'll probably end his presidency when he's 83 years of age. When I wrote the report, I thought that was very old of age, but when you look at the US, it can get even worse. Let me then recall the Assembly's main findings in Resolution 2519, which we adopted in October last year. Firstly, the constitutional changes pushed through in record time to eliminate the presidential term limits in the Russian Federation for the benefit of Mr. Putin and Mr. Medvedev grossly violated the Russian constitution itself. My explanatory report, which is almost entirely based on learned opinion by the Venice Commission, a bit of copy-paste of what's going on, sums up various procedural and substantive violations. If you want more details, read the report. Secondly, this ad hominem term limit waiver also violates internationally recognized rule of law and democracy principles. Thirdly, for these 2 reasons, we called our governments to refuse recognizing Mr. Putin as legitimate president of the Russian Federation after the expiry of his then ongoing mandate, so when he started his new mandate. What happened since? Well, not surprisingly, Mr. Putin, based on the illegal constitutional changes, represented himself, having made sure that not one serious competitor was taking place. His serious competitors were either in prison or dead and in prison, or barred from running on the basis of the most spurious, trumped-up grounds. The election itself was a complete farce. The numerous violations of the most basic election rules have been widely reported. On the upside, many international actors have picked up on our call to refuse the recognition of Mr. Putin as legitimate president of the Russian Federation. Among others, the European Parliament, several national parliaments and governments. Our colleague Sona Avesdotter reported back from her visit to Washington, D.C., that a bipartisan motion in the US Congress has been tabled and referred to the House Committee on Foreign Affairs, much in the same vein. As rapporteur for follow-up, I organized this hearing for 2 main reasons. 1, to remind us of our resolution and renew the call to refuse Mr. Putin's legitimacy as president, and 2, to publicly draw another conclusion from our findings, namely that Mr. Putin should not, or no longer, benefit from the personal immunity from prosecution that is customarily attached to being one of the troika of the top leaders in the country, the president Prime Minister and the Minister of Foreign Affairs. You're probably aware that the creation of the Special Tribunal for the Crime of Aggression, which our Assembly called for starting in April 2022, is underway. Discussions in the core group of over 40 countries supporting the Special Tribunal are in a decisive phase. Whether or not the Troika immunity would apply to such a tribunal is still disputed. I believe we can help out here. As Mr. Putin is not the legitimate president of the Russian Federation, he is not part of the Troika anyway. One of the most fundamental principles of international law is that illegal acts cannot become a source of legal rights for the wrongdoer. Conclusion to the contrary would essentially mean that might is always right. The only solution to prevent the spoiling of the international rules-based order is to deny the wrongful act its legal character. This principle, deriving from a Latin maxim, ex injuria jus non oritur, constitutes a general principle of law and thus a source of legal obligations under Article 38 of the Statute of the International Court of Justice in my hometown. In my view, this might be the most important conclusion from my resolution. As the waiver of Mr. Putin's term limit was unlawful and the election was stolen, he can and should not benefit from privileges and immunities customarily granted to lawful heads of states. And let me remind you how important the 83 years of age is in this respect. He can stay on with his immunity if you grant it to him until he's 83. And not granting it may be the exact difference between seeing justice at some point and not seeing justice. And while it might seem very remote, I would very much welcome Mr. Putin in The Hague. It looked at some point very remote for Mr. Mladic and Mr. Karadzic. So don't think it's impossible, but it may be very difficult. I'm very happy that we have Mr. Michael Kasyanov, former Prime Minister of the Russian Federation, actually the first Prime Minister under President Putin in 2000. And he's since evolved into a foreign agent according to the Russian law. No, and that should show you how much animosity there is. Dr. Gleb Bogusz, he's an expert in public international law at Cologne University, and Ms. Veronika Bilkova, she's the Vice President of the Venice Commission, co-rapporteur, and basically the source of much of our report. Thank you, Mr. President.
This one? Okay. Okay, good afternoon.
Peter, could you switch off the microphone?
Yeah. Good afternoon. Allow me first to thank Lord Keane, the chair of the Committee on Legal Affairs and Human Rights. It's a great pleasure to me, and it's an honor to co-chair this important meeting, this important joint meeting, and to welcome all our colleagues and our experts. Yeah, and we can now start our hearing. I will immediately give the floor to Mrs. Veronika Bilkova.
Good afternoon, ladies and gentlemen, colleagues. I would first like to thank for this opportunity to join this panel. I'm very looking forward to the discussion that we will have. As a public international lawyer, I found the proposals which have already been made and that I know will be made very interesting, and I'm truly looking forward to the debate that we will have. I would also like to congratulate Mr. Omtzigt, sorry for the mispronunciation, I'm sure it's there, for the excellent report, which I really enjoyed reading, not only obviously because it refers to our opinion, but also because it contains much more, and it was true pleasure reading it. Now, in my presentation, I will focus on the position of the Venice Commission, generally with respect to term limits, but more specifically with respect to the situation in the Russian Federation. The Venice Commission has dealt with term limits in several of its general reports, and I would like to stress two: the 2012 report on democracy, limitation of mandates and incompatibility of political functions, which set the general scene. And then a very interesting report, because it relates specifically to presidents, to the position of the president, is the 2018 report on term limits. It has 3 parts, and the first part exactly relates to the position of the president. So it's really appropriate for the discussion today. In addition to these general reports, the Venice Commission has also assessed term limits in some of its country-specific opinions, including those related to Belarus, Azerbaijan, Kyrgyzstan, and also the Russian Federation. So the opinion on which I would like to focus today is the 2021 interim opinion on constitutional amendments and the procedure for their adoption, which relates to the 2020 constitutional amendments adopted by the Russian Federation. Just to avoid confusion, it's called interim, which would suggest that there should be some final report or final opinion, but such opinion has never been adopted. So sometimes interim things may become permanent, which is the case for the moment for this opinion. As already noted by the rapporteur, these 2020 constitutional amendments on which the opinion focuses were exactly the amendments which modified the constitution of the Russian Federation inter alia, because it's a very complex set of amendments, but inter alia with respect to the terms of office of the President of the Russian Federation. Prior to 2020, to these constitutional amendments, the Constitution of the Russian Federation provided that, and I quote here, one and the same person cannot hold the office of the President of the Russian Federation for more than 2 consecutive terms. So 2 and consecutives. That was prohibited prior to 2020. The 2020 amendments removed the word consecutive, making the regulation actually stricter. And that is an element which was commended, praised by the Venice Commission in its opinion. Yet, and that is why we are having this discussion today, at the same time, the amendments established an exception for the former and the current presidents of the Russian Federation, whose previous or current mandates simply would not count. So irrespective of the number of mandates they've already served in the past, they can stand as candidates again, and it was already explained till when they could actually, or at least one of them, could be in the position. So that is the main thrust of the constitutional amendments with respect to the topic we are discussing today. In its 2021 opinion, the Venice Commission assessed this modification very critically. And it did so on several grounds. 3 were the main grounds. 1 was procedural in nature, and the 2 were substantive in nature. So I will now introduce these 3 main critical points that the Venice Commission has raised in its opinion. So concerning first the procedure, and we already saw in the morning that procedure and substance are closely connected, that we can't really separate them. So concerning first the procedure for the adoption of the constitutional amendments, in general, states are rather free to determine which procedure they will use for the amendment of their own constitution. Yet, once they decide that there would be a certain procedure, they need to follow this procedure. That's a logical consequence. This, however, was not the case in 2020 in the Russian Federation. The procedure which was prescribed by the Constitution and which foresaw the convocation of a constitutional assembly was simply disregarded. And it was replaced by an ad hoc procedure in 3 steps. That means there was a proposal first, it was then adopted by the 2 chambers of the parliament, that was the first step, then it was sent to the Constitutional Court for a very quick appraisal, and then there was the so-called nationwide vote, which is some kind of a not even a referendum, some kind of a plebiscite in a very strange way. Maybe my colleagues coming from Russia will have a better word for this. So this was not the procedure which should have been followed. Moreover, this procedure clearly did not offer any guarantees of a fair legislative procedure that would be compatible with the principles of the rule of law, because under the rule of law, it's important to follow a legislative process of a certain quality, and this quality was clearly missing in this legislative process. These were very important changes, not only the one that we are discussing today, there were other changes of the constitutions, and these changes were adopted in a very short time. It's actually an incredibly speedy procedure. There was virtually no space for public or even parliamentary debate, and I leave aside whether such a debate could take place in Russia at the time, but it was not taking place for sure. And the role of all the entities which took part, at least officially, in the procedure, that means the parliament, the constitutional court, and the public, was basically reduced to just nodding mechanically to the proposal submitted by the president. So this is the procedural problem, the first one. Now I'm moving to the substance, and there are two critical issues that I would like to raise and that are present in the opinion. The first critical point relates to the ad hominem nature of the amendments, obviously coming from Latin meaning targeting specific people. The amendments pretend to introduce a general regulation, and it should be the case because all legal rules should be general in their scope and in their application. However, in practice, they only apply, this exception to the new term limits. So this exception only applies to two people whose names we know. It's Vladimir Putin and Dmitry Medvedev, since there are no other former presidents of the Russian Federation. The Russian Federation is not the only state which from time to time adopts an ad hominem legislation. The Venice Commission has seen other examples of legislation, not necessarily on the same subject, but similar types of legislation, for instance, in Hungary or in Turkey, and it has always consistently criticized this approach. Legal rules should be general, not designed specifically to accommodate needs on concrete people. So that's the first substantive critical point. The second substantive comment relates to the very possibility introduced by the amendments for certain persons, for the two persons, to hold the presidential office for more than 2 terms. Actually, the report that I mentioned before, the 2018 report, contains a comparative study of several dozens of countries. And the Venice Commission found that it's very common to have limits on terms. So what the Russian Federation adopted is an exception rather than a rule at the international level. And the Venice Commission has repeatedly noted that the term limits are very important because it's one of the important checks against the risk of the abuse of the power. If power holders know that they will be sooner or later replaced by someone else, they have the motivation not to abuse of power too much. First, because obviously after they are removed from power, they might be held accountable. And second, because they know that if they kind of try to misuse of power, that could set a precedent in future that could be followed by their successors, and it could turn against them ultimately. The time limits on presidential office, and we are speaking here specifically about the office of the president, are particularly important in presidential and semi-presidential systems, such as the one of the Russian Federation, because their presidents have considerable power, or considerable powers. They are also particularly important in countries where the president is elected directly, simply because such presidents tend to have a stronger mandate, or at least tend to think that they have a stronger mandate. And finally, such time limits are particularly important in countries which have experienced autocratic forms of government in the recent past. Now you can see that the Russian Federation combines actually all these 3 elements. The president is elected directly, it's a presidential system, and it obviously has a tradition of an autocratic totalitarian past. So what the Venice Commission noted in 2018 applies here, and I would like to quote this sentence, which I like a lot and which also fits into the French setting where we are. In countries that have no democratic tradition and that do not have a developed civil society, the unlimited mandate of the head of state could introduce a new Caesar or a new Bonaparte, regardless of the model of government. And I think the developments, not only in the recent month, but over the years, unfortunately show that the concerns expressed by the Venice Commission, and not only by the Venice Commission in its opinion on the Russian Federation, have been fully validated. Thank you very much for your attention, and I'm really looking forward to the other presentations and to the debate.
Thank you, Mrs. Bilkova. We move now to Mr. Gleb Bogusz, expert in public international law and research fellow at the Cologne University in Germany. The floor is yours.
Thank you very much. Ladies and gentlemen, first of all, I would like to express my gratitude for holding this discussion, this very important discussion. And I would like to point to first to other important factors demonstrating the problematic nature of continuing holding of Mr. Putin of the presidential power in Russia. And secondly, I would like to address the international legal consequences and the relevance of the finding made by first the Venice Commission, then Parliamentary Assembly of the Council of Europe. First, it's true that Russian Constitution provide for the strong principles of democratic state, republican form of government, and it states that the only source and power and bearer of sovereignty of Russian Federation is the Russian people. The Constitution also prohibits the usurpation of power. Original version, as was already said today, provided for 2 consecutive terms as a limit of presidential power. In 1998, so 2 years before Putin came to power, the Constitutional Court of the Russian Federation clarified that this rule constitutes the constitutional limit and ensures the principle of change, of regular change of power. It's quite interesting then in this case that was initiated on the occasion of attempt to change the interpretation of this provision and to allow the President Yeltsin to stay in power on the basis of the fact of his election under the previous constitution. The Constitutional Court explicitly ruled out ad hominem provisions allowing specific person to remain in power, and also interpretation to this effect. As we know, Vladimir Putin has remained in power for almost 25 years as President and Prime Minister of Russia. Already in 2012, when he was elected for the 3rd term, many constitutional law experts doubted the interpretation allowing the 3rd presidential term. As a very minimum, it contradicts the object and purpose of this provision, and even the plain reading of this provision in the Russian language. The events following this election in 2012, such as campaign of repression against civil society, LGBTQ people, censorship and suppression of the free media, open refusal to execute the judgments of the European Court of Human Rights in 2015, and most fundamentally, the act of aggression against Ukraine are all direct consequences of this usurpation of power. And all this was made with the crucial help of manipulation and use of electoral procedures, such as election. All of them have been found by the respective monitoring bodies as not free and fair. The final step was already described very well in the opinion of the Venice Commission. I just would like to point on some details of this amendments, of this procedural mechanism that allowed these changes to happen. Initial version of the amendments to the Constitution did not contain any amendment to this effect. It just provided for elimination of this consecutive provision, the wording. This amendment was introduced in the last moment when there was a discussion in the Duma in the Russian parliament. And it was made with procedural irregularities, with violation of the regulation of the Duma. Moreover, what was also important that this amendment was not even part of the respective provision that was put on the so-called all-Russian vote. So technically, there was no popular approval of this amendment because it was not contained in the main body of the amendments, but was hidden in the technical provisions. Original version of constitutional amendment, had they have been adopted, would not have allowed Mr. Putin to be a candidate for the election in 1924. So it was already mentioned by my colleagues that there was no proper campaign, there was no proper debate over this amendment, there was no option to argue against these amendments publicly, and quite tellingly, this amendment was not even part of this state-organized campaign. It was hidden. It was hidden under the smoke screen of other amendments. Most of them have not been quite relevant to what actually happened. So by the so-called presidential election this year, Putin has fully cemented personal dictatorship by suppressing freedom of expression, suppressing opposition, prosecuting political opponents inside and outside the Russian Federation, and creating a system of legislation that criminalized political views crucial of his regime. Situation critically escalated after the full-scale invasion of Ukraine in February 2022. When we talk about election in Russia, we should be aware of the very important fact that significant number of Russian people, of Russian citizens, have been deprived of their right to participate in the elections. According to leading NGO, election observer Golos, which was at that time even received governmental awards as being the leading organization, and now it's of course banned as foreign agent and etc. This number reached a colossal number of 9 million people. 9 million people under various pretexts, being involved in extremist activity, even without criminal conviction, and a lot of people, politicians like late Alexei Navalny, Vladimir Kara-Murza, Ilya Yashin, all of them were deprived of their passive electoral right to be elected. And most importantly, this list includes a lot of regional leaders, popular politicians. So it's all of them have been deprived of any way to compete with Mr. Putin in any meaningful way. A lot has been said about the procedure this March this year, but the most crucial fact, the elephant in this room, is of course the elections, so-called elections in the occupied, illegally occupied and annexed territories, regions of Ukraine, 6 regions. Without the consent of the sovereign Ukrainian government, it's needless to say that this procedure and these regions have not been open and to any observations. And that is, of course, what happened there cannot be verified in any way. And of course, this procedure had a clear purpose to cement an occupation. And this is contrary to the obligations of states not to recognize this situation as lawful. So this is, I think, very important to be in mind when we talk about the consequences of these elections. The aggression against Ukraine, and specifically crime of aggression that was committed, is one of the grounds mentioned by the Russian constitution that doesn't allow a person to be a president anymore. So the whole context of the election, of the occupation of sovereign country, provides for the very serious international legal problem as to recognize not just this election but the results. I now turn to the possible legal consequences of finding Mr. Putin's mandate illegitimate. As was already said, the major issue that is currently under discussion is the establishment of the Special Tribunal for the Crime of Aggression and the personal immunity of Mr. Putin. I will focus on this issue. The Assembly has clearly stated its position. It don't have a critical mass of states that would clearly stated recognition or non-recognition of both elections and Mr. Putin as head of state. But the lack of consensus means that at least we have to be in mind and we have to acknowledge that the status of Mr. Putin is not very clear with regard to personal immunity. The international rule is very strict. There is no significant debate about whether personal immunity applies to head of state. And the international practice is also very telling. We have the International Court of Justice judgment in the arrest warrant case. We have the opinion of the International Law Commission. But nevertheless, it's important to understand that this immunity applies in the interstate level. It should not be an obstacle for investigation and prosecution of the head of state, even if it's recognized formally in the international or regional tribunal. If you look at the old 20 years ago resolution of the Institute of International Law, it clearly says that there is a possibility to prosecute persons entitled to personal immunity in the not just international but also regional tribunal. Although the resolution of the Parliamentary Assembly is not binding on member states, it's of principal guidance for the organs of organizations, including Assembly itself, in working on these proposals. And the key consequence is, of course, that concerns the personal immunity of the President of the Russian Federation. Non-recognition is, of course, political act, and the criminal tribunal cannot replace the states in making such judgment. However, the argument can be made that the non-recognition of the head of states finding also affects this immunity. So the important in this regard that in any future arrangement, in any future agreement on the special tribunal, it should avoid provisions that assume the existence and application of personal immunity for Russian and Belarusian leaders involved in the crime of aggression. So the very concept of the special tribunal for the crime of aggression is antithetical to absolute and potentially, it's a case of Mr. Putin, lifelong immunity for the key potential defendants. Not everyone here in this room are international lawyers, but the crime of aggression is a special crime. It's a crime that is leadership crime. Only persons who control and direct political and military action of the state can be prosecuted for this crime. In the light of the debate, it's critically important that this future special tribunal should be made as international as possible to strengthen the case against potential argument of the personal immunity. And therefore, the idea of transfer of proceedings from the national jurisdiction, where the immunity issue may arise, should be avoided. Finally, I would like to state that individuals who persisting in the commission of international crime, particularly the crime of aggression, should not benefit from the results of their transgressions, should not be allowed to use and abuse the rules of international law aimed at protecting sovereign equality, political independence of states. The promise of immunity, if it would be made instead of deterrence, would create an incentive for the persons like Mr. Putin or Mr. Lukashenko to continue and persist in commission of crime of aggression and other international crimes that accompany this war. Thank you very much for your attention.
Thank you, Mr. Bogusz.
Sorry, could you switch off
Could
your
you
mic?
switch off?
If I could, being the co-chair with a working microphone, now invite Mr. Kazhinov, the former Prime Minister of the Russian Federation, to address us. And thank you for being here and to lend us your perspective on the issues that have been raised.
All right. Thank you, Mr. Chairman. It is great that you arranged such a discussion, and especially just I'd like to start that all democratic opposition of Russia and millions of Russians supporting democratic opposition, they were very pleased and very much satisfied with the fact of adoption of the resolution 2519, October 2023. We see this as an act of solidarity with Russian democratically devoted people, act of solidarity because of simple reason we believe that not only us think that Putin is not legitimate, and not only us believe that Russia, in accordance with the main articles of Constitution, is a democratic state, but that's absolutely destroyed by Putin's dictatorship. And in fact, there is no need to provide reasoning for this illegitimacy, which already the other panelists already described, and the resolution itself gives this, I would say, reasoning. I would like just to express my thanks to Mr. Omsik and the committee and the Assembly for describing this and making this public for the whole world. And that is demonstrates very principled and morally justified position. Consequences. I think just the consequences for the regime, just we can count them by very easily. First, there is a deep understanding that what happened with Russia under the Putin's leadership during last 2 decades. It emphasizes immorality of the regime and personal responsibility of Mr. Putin for the act of aggression against independent Ukraine and the crimes and war crimes against humanity committed by leadership and just all those generals and the main actors. We should admit that resolution doesn't create an effective influence of Mr. Putin's behavior. He doesn't change. But recognition of the illegitimacy create an influence on the millions of Russian bureaucrats. I emphasize now just in Russia we have already millions of bureaucrats. And they all see that principled and consistent position of the West inevitably leads to the collapse of the Putin's regime and punishment of those responsible. And bureaucrats more and more try to avoid some kind of situations where they could be seen as supporters of Mr. Putin, and therefore to be brought for responsibility together with the main actors. They live in the situation of survival and dreaming about just a better future. Serious weakness of Mr. Putin will lead to at least silent strike by all those bureaucrats. It means that Putin should be seen as defeated, as weak for them and for many Russians. Worldwide recognition of the Putin's illegitimacy is an important step in this direction, and it counters his criminal activity. This brings EU leaders for better understanding how Putin could be changed and how Putin aggression could be ended. That is, again, it's very important to emphasize that Putin should be seen as defeated, and it should be seen by Russian people first of all. And I think this thinking by EU leaders could bring them to more stronger and, I would say, more brave decision-making process. I believe that all those people who committed just the war crimes and crimes against humanity will be brought for justice. I also believe that the act of aggression against independent Ukraine will be considered by a special tribunal, so that all those responsible will be brought to justice to account. Let me now just try to turn a little bit to political atmosphere, and I'd like to emphasize that we see now, after these so-called elections, or just new illegitimate mandate, Mr. Putin decided to operate just with the lower way of risks. He believes that war of attrition, that is the way which leads him to his victory. He believes that economic potential and manpower potential of Russia, of course, larger than Ukraine, and he believes that all these disagreements inside European Union and also just uncertainty during election period in the United States would bring a situation that Ukraine will not be supported strongly, and Ukraine will not last with such, let's say, not counteroffensive operation, even for keeping the position on the battlefield as it is now. And he believes that sooner or later, European and American leaders would press Ukraine for negotiations to accept his terms of, I would say, ceasefire, or terms of capitulation, in other words. Here. And in fact, he's even changes in the cabinet, just appointing the economist as the Minister of Defense, also demonstrate that he ready and he chosen this way to adjust the situation inside inside the Ministry of Defense and inside the industry. Mr. Putin, we should admit, within a short period of time, managed to transfer economy to war footing, while Ukrainian government didn't achieve this. And now just Putin's Russia produces ammunition 5 times more than European Union and US together. Although we know just investment already being made here in Europe for building production of ammunition, but still at this particular period and this year, Mr. Putin have an advantage of this. The most important thing is just that he doesn't want to have the total mobilization. That's war attrition allows him just not to have mobilization, not to create additional sensitivity inside the society, Russian society. Russian people keep patience. Especially, I would like to emphasize that in the big cities, Mr. Putin keeps the situation that nothing going on, no war exists. People living as before, even better than before. In the big cities, Moscow in particular. Moscow is 10% of Russian voters. All restaurants are full, all theaters are full, all museums are full. Putin enjoys drafting people from remote areas where just they live in poverty. An initial payment for a person who signed a contract for coming to the war in Ukraine is already around 15,000 euro. That is more than 3 years' salary of people living there. That is the way of keeping just the manpower in a battlefield right now. To have extension, or to have I would say another offensive operation, of course he needs more people. That's why just important to understand that Putin working on thinking just in the way of war attrition. But he understands that war and attrition couldn't last long. Because right now, he already spending 6% of GDP for this war. It is not a critical. For instance, Israel spending 5% of GDP for military expenditure, but they live permanently in the atmosphere of war. 6% is not critical. But I'm coming to the main point, just if we would like Mr. Putin to be defeated, which is, of course, that will be, say, recreation of independent Ukraine, and of course, just restoration of territorial integrity, and of course, elimination of threat for the whole Europe, and beginning of changes in Russia. If we want this to achieve, we should increase support of Ukraine. Now Ukraine gets annually 120, 130 billion euro. Mr. Putin spends 170 billion euro for this war. He has an advantage at 6% of GDP. If support of Ukraine would be doubled, which is absolutely easy to achieve by European and America, it will mean just that Mr. Putin should level up his spending. It means 12 or 15% of GDP. That's already beginning of the catastrophe, economic catastrophe. That's why we should make a decision, seriously consider this, and make a decision this year, so that not to allow Mr. Putin to further press Ukraine. That is my major point of this. And again, I'd like to thank just for such an interest to my country and the future, and the legitimate Mr. Putin. That is a very important step and signal for the whole Russian society, how just our friends here in Europe look at Russia and what they want to see in the future. Thank you.
Thank you, Mr. Kasanov, and for making the point that efforts made now to support Ukraine will perhaps prevent the need for far greater efforts in the near future.
Exactly.
I wonder if I could begin questions by just directing one to Dr. Bogusz. And it may seem rather obvious, but is there any precedent for the challenge of domestic legislation affecting material constitutional change in a state other than by the domestic courts of that state?
It's no precedent known to me that the internal constitutional changes have been questioned before the international courts and international tribunals. However, of course, the issue of recognition has been raised several times, including in the proceedings before when deciding on jurisdictional matters in International Criminal Court, for example, when it's dealt with the situation of the government, of the several governments, subsequent governments in Egypt, and there is a ongoing discussion about states like Myanmar, Syria, Venezuela. So this is basically maybe the only case when there was many decisions on the national level regarding the legality of the government. But all these cases have been dealt with the situation of the competition for the being legitimate government. So the problem of Russia that we don't have any alternative right now. So the question that is often asked, I think it's a legitimate question. So what is instead? So what you suggest to have in Russia if this government is not legitimate? So I think that assembly resolution, the language of assembly resolution is very helpful. It suggests that some kind of limited recognition of de facto authorities in Russia. So it doesn't question the fact that Mr. Putin controls the situation in Russia. However, the recognition of de facto authority doesn't mean that its authority is legitimate. And it's particularly important when we're deciding on the question like immunity.
Thank you for that. Peter, do you want to come in at this stage with questions?
Thank you, and well, sure, Chairperson, and thank you very much for three excellent introductions which help us understand what is going on, which for us is very difficult, both at a legal level, which we don't often use as politicians, because we find it very difficult to think in terms of legality of a presidency. We've probably had 20 or 30 years of the idea that we could not see this kind of backsliding. But I would like to aim my question at Mr. Kashanov, who has been very eloquent, and he obviously has some inside information about the way the Putin regime works, having dealt with him for a few years himself, and was very clear on what the West needs to do, namely double its effort and make sure that we beat Russia in this war. Could you kind of give a what would you expect to happen if we don't do that? I mean, we've seen that the entourage of Mr. Trump seems to be willing to force Ukraine in peace negotiations. If that happens, what would you expect the Russian Federation under President Putin to do?
Mr. Omsik, you're pressing me just to describing just the most negative scenario. Just I don't know whether just I need to do this, but I'll try to give you, of course, this feature. First of all, of course, Mr. Putin wants to be respected by international leaders. He wants to be treated as, at least as a president of the United States. He wants the Europe to recognize that Russia is the dominant country in the continent. And you see from different his statements, he many times said just unpleasant words about just different small or medium-sized European countries. He wants, of course, to get, I would say, recognition that he has a right for not only influence, but the right for making changes in all territorial former Soviet Union. Ukraine, that is the most important country because it's the biggest country. Always it was the closest country to, mentally to Russia, same as Belarus. And it's important for Russians. And Russian families very much interconnected with the Ukrainian families and Belarusian families, but mostly with Ukrainian more. And that is important for him. Just main problem for him, he doesn't want to see Ukraine as independent and building up a real democracy. In this case, Russian people would have a look at the neighbor country and say, why Ukraine can't do this, build up a prosperous country based on democratic principles, but Russia should stay under dictatorship with the third of population under the poverty line. That is the issue of keeping personal power. Right now, he already overcome all those red lines in understanding just what is legal, what is illegal. And right now, of course, he would wish to stay forever, because just we very clearly just describes what the future he should come. Definitely, that would be the case. And in reality, of course, we shouldn't allow Ukraine to collapse. if Mr. Putin, dictator Putin, would be seen as winner of this battle, it means just the whole change of whole architecture of international security and European security, first of all. He already almost destroyed this. And the next step will be just after Ukraine, immediately Moldova. It will take 2 days, 3 days to occupy and to destroy Moldova. And then he will understand that it's allowed to behave this way. I would remind you the year 2008 invasion to Georgia. There was a ceasefire plan signed by Russia. Within 3 months, no single point was implemented by Russia's authorities. Moreover, two territories, 1/3 of territory of independent Georgia was annexed de facto. And 3 months after, European Union and the United States came back with the relationship with Mr. Putin as business as usual. Mr. Putin said, oh, that is the way how just the West world allow me to behave. That, of course, brought his to the conclusion that annexation of Crimea would be something the same. And he was right. Just a couple of statements, a little sanction after annexation, that's all. He didn't expect that the full-scale invasion of Ukraine would come to such situation what we have now. He was disinformed about possibility of occupying, and he thought in reality that within 3 days or 3 weeks maximum, Ukraine would collapse, and puppet government would be established there. But he made a mistake. Now for him there is no way, but his nervousness is growing, and his recent statements demonstrate that. For instance, when he said that he is ready to apply nuclear weapon if Russia faces strategic collapse in Ukraine. Of course, it's bluffing. But I know that here in Europe, there are political groups which understand that take it as a serious. But there should be more decisive discussions among leaders here. It is really bluffing. Mr. Putin knows that the appropriate answer for such an aggression would be given by NATO countries. And he already got a message that it will not be nuclear answer, not nuclear reply. There will be just usual way, but destroyment of infrastructure and all army and himself. That's why I strongly believe that Mr. Putin is not prepared to apply nuclear weapon. You should take understanding that Mr. Putin is not an army general who is ready to die on the battlefield. He's the KGB officer. And try to transfer responsibility for somebody else. He's doing this right now. He's saying just the West is responsible for what's going on. And people just believe. That's why I'm saying just there will be dangerous development, including taste of NATO Charter, whether it works or not. Thank you.
I wonder if I could ask the obvious question that Peter addressed. What is your perception of Mr. Putin's position as President of Russia in the event that Ukraine is successful in Russia out of? Will that itself be sufficient to fundamentally undermine his position as president, or do you consider that even in those circumstances he will be able to maintain his dictatorial position over the Russian frame?
That is the most important point. That is the crucial. I believe that will undermine his, I would say, control position. He says there is no will be the main point. Mr. Putin by everyone, by every Russian, as weak, and the leader who not a leader anymore, whom they believed before he would achieve such a goal. And in this case, first of all, within the and military system, people would start to understand that Mr. Putin doesn't any more of their interests. He cannot give them anything. He already under international law and made us ordinary people just gradually will start understanding, change their attitude to the war and to Mr. Putin in particular. The beginning of changes in Russia. What we, of course, need to achieve Ukraine would defend its territorial integrity, just not start. And that's what we coming to the no Mr. Putin would do immediately, but changes would start. I hope he will somehow resign.
I ask if there are colleagues who would like to raise questions. Thank you.
Thank
I
you.
can't see your nameplate, but
I don't have one. I'm the Austrian Perm Rep to the Council of Europe. Thank you for allowing us to participate in this very interesting debate. I would ask to repeat that he says the problem of immunity is more acute in an account solution, special tribunal, crime of aggression, proceeding.
Thank you for the question. So I mentioned the general, we can say, exception from the rule of of personal immunity. I mentioned the way in the arrest warrant judgment of the International Court of Justice that international may execute. May try individual incumbent head of government foreign affairs. It depends how we define international tribunal, and international tribunals, as it is following the international case law, in particular judgment of the Special Court for Sierra Leone, are not organs of the state, not originated from the state, from the national proceedings. So they are serving the interest of the international community, and it's not just delegation of jurisdiction. So this is an idea that international courts created by international treaty. So all international courts are created by states, but they are not just exercising delegated jurisdiction. They have the source of this jurisdiction in the international law, international criminal law, and this is an idea, as far as I understand, in the current debate in the Council of Europe, that this is not just European answer, and it's, of course, not just Ukrainian answer with the help of the Council of Europe. It's international tribunal. So the idea that international tribunal should be clearly defined as international body, not just extension of national jurisdiction.
thank you. Peter, would you like to say anything further to sum up before we conclude? I apologize. We have a further question.
Hello, thank you. I have 3 questions for you. So the first one, what can you say about Chechnya? Do you consider Chechnya as an independent occupied country or a region of Russia? The second one is, how do you imagine the future of Chechnya? And the last one, what you plan to do to reinforce sanctions against Russia? Thank you.
I'm not sure to whom those questions were directed, but,
Mikhail Kasyanov.
well, in that case, we will invite a political response, not a legal response. Thank you.
I don't know what organization you represent here, just...
The Chechen National Liberation Movement United Force.
Yeah, first, of course, my answer is very clear. I consider that Chechnya is part of Russia. That's the answer for your first question. And the second question, the answer is, if Chechen people in a free, I would say, plebiscite, and a free election decide to be independent, that's their right. But it should be not in a, I would say, atmosphere what exists right now in Chechnya. That's absolutely unacceptable. But in the future, when Russia would, again, build up a democratic state for themselves, Russians will make this choice. And in this case, of course, just all national groups, national republics could make their choice whether they stay inside Russia or not. I believe that, I think, again, if it is free discussion in Chechnya and in Russia, I don't think that Chechen people would be willing to leave Russia. I may be mistaken, you know better, but it is I'm talking about democratic Russia. But such a discussion couldn't appear before democratic Russia re-established.
Thank you. Thank you. Now, Peter, could I come back to you and ask if there's any further points you want to make in summing up, having heard our experts?
Well, there's not many further points I would like to make. I would really like to thank Ms. Bilkova for the work and the clarification of the work of the Venice Commission on term limits, and especially on Russia, and hoping obviously that Russia one time will return to be a member of the Venice Commission. But Russia actually did participate in the early stages of the discussion on her report. So this is not a report about Russia, this is a report written together with the Russian institutions. I'd like to thank Dr. Gleb Bogusz for his very clear outline of international law. That helps a lot. And obviously Mr. Kashanov for clearly not only making a complete legal case, but also the political case of not forgetting what's going on here. This Council of Europe was actually founded to prevent major wars between nations. And it seems that we've sort of gotten used to it, that two member states of this country, first it was Georgia, Georgia being invaded by Russia, Moldova being occupied partly by Russia since its inception. And in case you might want to think of those conflicts as region of minor wars or a sort of a short war to reach something, the fact that we now have an all-out war by the Russian invasion of Ukraine means that we're crossing many borders which this institution was actually prevented from having. And the fact that we're still very much lukewarm about our reaction. If you look at the speeches of Mr. Churchill when he was here, or when he had his famous speech in Zurich, where he asked for this institution to be established, we're actually pretty weak. We're pretty weak in our response. We don't seem to believe that, we for a long time believed that sort of nice diplomacy would do the trick here. But nice diplomacy with Mr. Putin will not do the trick. It will be the hard work by the Ukrainian people, and hopefully the hard work by the legal community of making sure we have the right indictments. And I'm very happy to have seen a few more indictments the last days of the International Criminal Court in The Hague, to make sure this war ends. And a lot more thinking and hard political action needs to go in there. Thank you.
Thank you. And it is a combined effort. Could I take this opportunity to thank each of our experts for attending this afternoon, for their contributions today. Could I also thank colleagues for being here on a Thursday afternoon. I know that's quite challenging in the circumstances of how the Council operates. And can I also extend my thanks to the interpreters and the media staff for supporting us. That does bring us to the close of this hearing and to our work for the week. So can I wish all of you a good summer's break, and thank you again, all of you.
Thank you.
Thank you.
Thank you.